Morrison Reddick Waite was born November 29, 1816. He died March 23, 1888. His family was part of the upper class. His father was a lawyer and a farmer. He was born and grew up in the state of Connecticut. Morrison then moved to Ohio. He went to the College of Yale University and studied law. He played no real role in politics during the Reconstruction era and was declined a U.S. Senate position 2 times. Morrison Waite was sworn in March 4, 1874. He was the 5th option for Supreme Court Justice. 1 person declined and 3 withdrew when they were threatened with Senate rejection. His colleagues resented him because of such a surprise appointment. The Waite Court weakened the concept of national citizenship based on the 14th Amendment. In cases involving violent interruption of political meeting, refusal to allow a registered Black American to vote, and lynching, the federal government was not responsible in efforts to protect Black citizens. That responsibility was left to the state governor. Similarly, the civil rights cases permitted racial segregation in privately owned places of public accommodation. On the other hand, African Americans had been sustained in their right to serve on juries in the Straughter v. West Virginia trial. Waite's most famous decision was the Munn v. Illinois, which upheld the right of state legislatures to enact Granger laws, in this case, the regulation of grain storage rates. Retrieving a 17th century English decision, Waite held the registers could regulate in a matter affecting with a public interest. Later, however, the contravailing interest of the railroads to avoid such regulation was established when Waite, while avoiding express disavowal of the Munn Doctrine, permitted a broad reading of the 14th Amendment that limited the government to regulate business. In 1871, he was appointed by President Ulysses S. Grant to serve as a U.S. counsel to the International Commission set up in Geneva to attribute claims against Great Britain. Evidence of the court's productivity was the fact that he decided some 3,470 cases with opinions during Waite's tenure. While both the large number of cases decided and the variety of issues confronted reflected the lack of discretion of the court, it reflected his own prestigious work habits, since about 1/3 of these options were drafted by Waite. Believing that the federal commerce powers must keep pace with the progress of the country, the primary running theme through Waite's opinions dealing with economic regulation was the balance of federal and state authority.
Dred Scott was a slave who was born in Virginia in 1795. He was purchased as a slave by Dr. John Emerson and taken to Illinois in 1833, where slavery was banned due to the Missouri Compromise of 1820. After Emerson died in 1843, he left Scott and his family to his wife, Eliza Irene Sanford. After moving back to Missouri that same year, Scott argued that since he lived in the state where slavery was banned, he was declared a free citizen. Northern anti-slavery justices John McLean of Ohio and Benjamin R. Curtis of Massachusetts also helped with this case. They argued that Scott should be freed under the Missouri Compromise because he had traveled north of the line, whereas the court's Southerners wanted to rule the compromise unconstitutional, disagreed with the argument, and decided to give Scott and his family to Eliza's brother, John F.A. Sanford. Scott tried suing once more in the federal court and eventually made it to the U.S. Supreme Court. So, was Dred Scott free or a slave? This was the main question for the decision of Dred Scott v. Sanford. This decision was ultimately made by Supreme Court Chief Justice Roger B. Taney. The court decided 7-2 in favor of Sanford. Every justice submitted an individual opinion justifying his position, with Chief Justice Taney's being the most influential. Under Articles 3 and 4 of the U.S. Constitution, Scott wasn't considered a citizen, and only Congress could confer citizenship. According to Taney, African Americans, whether they are a slave or free, were not American citizens. As a slave, Scott was also considered property and had no right to bring suit in federal courts. This decision said that slavery could exist anywhere and no state could forbid slavery within its borders.